Welcome to the Estate Blueprint, Planning Your Future with Tom Begley.
Hello and welcome back to the Estate Blueprint, Planning Your Future with Tom Begley, where clarity meets compassion. For decades, Tom has guided families through complex estate planning decisions with wisdom, care, and legal precision. My name is Kevin Rosenquist, and today we're going to talk about second marriages. We'll get all in on that. Tom, welcome back. It's good to see you.
Good to see you as well, my friend. So what do you have to fire away with?
All right, you ready? Well,
Yep.
I'm curious what's different about planning for couples who are in second marriages versus couples who obviously are in a first marriage.
Well, typically when there's a first marriage, and not always, but oftentimes any children that either the husband or the wife has, or the two spouses of the same sex have, they are all from that individual marriage. So I've been married for a long time, 35 years, and I've got 5 children with my wife. And so, if something were to happen to us, we're not too worried about any planning issues because we're pretty much on the same page. And I mean, there are some exceptions to that rule, but generally we agree that if something happens, these people would be in charge of the children's money. These people would take care of our one minor child who's left, and usually you're on the same page. The big issue when you have children from a prior marriage, which is the big issue with the second marriage, is that you want to take care of the person that you married. On the other hand, the objective for most all of us is that when both of them are gone, and I'm just going to use a heterosexual couple, just as an easy example, that whatever he brought into the marriage, goes back to his family, and whatever she brought into the marriage goes back to her family. The problem is you can see a lot of drafting mistakes, and which cause a lot of problems.
What kind of problems do you see? What's most common?
So the big thing that you see is two issues. One is people forget that their assets, many assets such as retirement plans and insurance and annuities, they pass outside of probate to a designated beneficiary. And sometimes people leave stuff to their spouse thinking that when the spouse is gone, that's going to be going back to their kids. So that doesn't necessarily work. But the main thing really is the will itself. A lot of times people, because they're so in love, especially after they get married, they look at each other and say, I'll take care of yours, you'll take care of mine. And what happens is we'll call it the Brady Bunch gone bad will. Mike and Carol Brady, they've got the 3 kids each, and they get married and they love each other so much that they go to the local attorney who prepares a will that says, I leave everything to each other, and then I'll leave, when we're both gone, all 6 kids split everything equally. Now, I have to tell you, which is even more embarrassing for some members of my profession, is they actual draft wills, which I call death roulette. Whoever dies second wins. Basically, in this case, let's say Mike's will says I leave everything to Carol and vice versa, but his will says if Carol dies first, everything goes to his kids only, and her will says everything goes to her kids only. So, like if Mike dies first, Carol gets everything. Carol dies second, and her 3 girls get everything, and Mike's boys get nothing. That I do see. But the one thing you see a lot is the proverbial road to hell paved with good intentions philosophy, and that is leaving everything to each other, then naming all 6 kids. However, what happens is, let's say in this case, Carol passes on first, and Mike gets everything. And I've seen this happen far too many times. Mike, a few years down the road, will pick up the phone and give a call because for whatever reason, he needs to change the will. And it's usually not in favor of Carol's kids. There are some people that are just nasty out there, no doubt about it. But most people suffer from what I call the 8th deadly sin. And the first 7 are, we've heard before, greed, gluttony, pride, etc. But the 8th one, which I've come up with, is called rationalization. So Mike's not coming to the office to stick it to Carol's kids, but he'll come in saying, my boys are having some issues, and I think they really could benefit from the money more. The girls are okay, but they've all married into very good families, and they'll have great jobs, and this money's not going to change their lives. So they come and say something like that, and then what happens years down the road is the plan that Carol thought Mike would honor when she was breathing her last breath winds up being dishonored when he leaves everything to all of his kids at the expense of hers. So what you can wind up doing is recognizing you can take care of your spouse and still take care of your children. So that's done in two primary ways. The first is a form of marital trust. And what the marital trust does, it can take any of the assets that you own or in which you have an interest, such as those non-probate assets, the retirement plans, insurance, etc. And you can direct that when you die, all of your assets will go into a trust for the benefit of your spouse. And you can be very flexible as to what sort of provisions you make for them. Some people at the very least will say they get the income. Some will say they get the income plus, whatever they need out of principal for health support and maintenance. And some people will give some extra privileges. The idea often I see is that if somebody's recently married, the allowance in the will is going to be a little bit stricter, whereas the couple I had last week, they were 35 years married, and they certainly were very expansive about what they allowed the other to have. But then really what these marital trusts will say is that when the surviving spouse passes away, whatever is left in the trust is going to wind up going to his kids. And because he understands that whatever her will is going to leave everything to her children. And that's a fair way to work things out. Another thing that we can also do is regarding real estate, we can give what's called a life estate. A life estate can be given by deed, but in this case, I'm talking about one that's provided in a will or a revocable living trust. And at that point, you're giving the spouse the right to live in the property. But the thing I like this, which is much better than the life estate and the deed, is that you can put some conditions on it. So, for example, when I leave a life estate behind, let's say in this case, we'll go back to the Brady's. If Mike leaves Carol a life estate in the home, and let's say that they own it 50-50, but it's a tenancy in common, so really she can't sell it unless let's make an easier example. Let's assume he owned the home before she got into the picture. So he owns the house. He leaves her a life estate, and she lives for a number of years. Then passes on. That's fine. That happens a lot of the time. But when people are relatively young, especially because we're living longer and longer, things may change. So I usually put down some exceptions to life estate. One is I want to have an understanding that the survivor is probably going to pay the carrying costs. By that I mean they can live in the house, but they've got to pay for the real estate taxes, homeowners insurance, utilities, etc. So the other is that they can, and if they don't pay it, then the life estate would be extinguished. The other way would be is if they voluntarily decide it's time to move and they just put something in writing saying, I'm out of here. The others, if they abandon the property. And the two big ones that I've come up with over the years have been, first, and this is not something I came up with, is if Carol decides to get remarried or cohabitate. Mike doesn't mind Carol living in the house. He doesn't mind the girls living in the house, but he does not want his successor or replacement to be
successor. Yeah.
And the other is reflecting the fact that we have so much going on as far as long-term care. And what I've done inside mine is I'll state that if somebody enters a long-term care facility on a permanent basis, that it would extinguish then. And that way we could expedite, planning for public benefits to pick up the tab. One thing also, which is important to do when you actually put do this trust inside a will or within a living trust, you can have some flexibility. For example, I just said once, if you're married for a few years, you may want to give a little bit. Married for many years, you may want to provide a little more expansiveness. But two issues that I see are, what you want to do for your children. Sometimes people don't want to have to wait around for their stepmother to die or their stepfather to die. So sometimes what you'll do is you'll set up the trust, but you'll say, I'm going to say I'll leave 80% to my wife in a trust, but I'm going to give 20% to my kids now so they get something. The other thing that I do think it's very important to draft is language that says prior to the principal being invaded, that they have the opportunity, whoever the trustee of the trust, to look at the resources that are available to the surviving spouse. And that would be the income he or she has, any assets they have in their own name, etc. I'll give you a sad example. Some years back, there was a second marriage. They were both in their late 40s, early 50s, and she passed away somewhat suddenly. And they did have children from her prior marriage, and she had left him a trust and said that he could get the principal for whatever he needed to maintain his standard of living with. The sad thing that happened there was, to be blunt, he was a pig. He had a decent salary, still young if he was working, had assets of his own, but he didn't spend a penny of his own money. Basically, all the household expenses, all of his living costs, he tapped out of the trust. And he spent a ton of money over the years. And basically, really what he did was he stole from his wife's children, because he should have had the responsibility or some ethics to not just be a glutton and use all of her money, because really what that did was save an inheritance for his children at the expense of hers. So that's the nice thing about putting that clause in there, that language, and it makes sure that the person's taken care of, but it evens things out between the two families or two sides.
Where does a prenuptial agreement fit into this whole situation here? Does that kind of help, keep some of these negatives that you've been talking about from happening?
A prenup is valid for a few reasons. First and foremost, you can actually waive any right or have your soon-to-be spouse waive any right to an inheritance. And that's important because in New Jersey, if you don't have a prenup, and let's say I passed away and I didn't leave my wife anything, which would happen, but in this case I didn't leave her anything, she could go to court and ask for what's called 1/3 of my augmented estate, and that's the elective share. So by the augmented estate, it's not just what would pass through my will, but it would pass through any other assets in which I had an interest. Once again, the retirement plans, the insurance, etc. Actually, one exception, which is kind of odd. Life insurance that goes to another person is not counted as part of the elective share unless it's going to the spouse. That does count, which is kind of a cheesy rule.
Okay.
But that's quite important. The other problem you have or obstacles, what's called the omitted spouse share. And I had a case some years back where a gentleman, a true prince among men, and I say that because sarcasm, which used to be my second language, I think is leapfrogging to be my first, had been married for 45 years to wife number one. And if you saw him on the street, you'd think a nice, happy family. They had several children. And the wife passed on. And then he got remarried within a year to the woman with whom he'd been having an affair with for 35 years. So, he did have the right intent to take care of his children. He actually had left her assets by right of survivorship. In his will, he really wanted to take care of one of his children. He had an adult child who was developmentally disabled and was able to live with some assistance inside this condominium, really nice condominium that he purchased along with a little bit of money. The problem was the second wife was not so honorable, and when her husband passed away at the expense of a disabled child, which I think is beyond shameful, she actually went to court and said, well, because they don't count the non-probate assets for this one, she said, he didn't name me as a beneficiary in the will, and I'm actually entitled to half. Now, just to be clear, this comes about when someone signs a will before they get married, before they get married. So in this case, about a month or two before he had gotten married, he had signed the will and also established for his soon-to-be bride to get all this money, but the hundreds of thousands she got was not enough. And she basically forced the sale of his home and forced this son who had certain significant limitations onto the proverbial street. It was quite sad. So the nice thing about a prenup is that it eliminates those rights whatsoever. and then you can give them whatever you want. The other thing it can be used is to actually define what the survivor will get. So I've had some cases where it worked out well because the estates were somewhat significant. And one case, the gentleman had a ton of money and she didn't have a heck of a lot, but she had done a lot for him over the years and had given up a lot to get married to him. So it was inside the prenup saying that he was going to establish trust with X number of dollars and provide for certain needs. So you can actually use that to be, somewhat explicit about your wishes.
Okay. That's interesting. Yeah. I mean, people, there's a lot of people out there who aren't good people. We've certainly heard a few stories from you about some people who certainly aren't good. Are there other steps that someone can take to make sure that they want to take care of their spouse, but they want to preserve their inheritance for their kids? Like, when you're talking to someone about planning in the second marriage, what ultimately do you suggest?
Well, there's a couple of things. In addition to having a will and a or a revocable living trust that balances out the desires of taking care of your surviving spouse, but taking care of your own children, you can also make sure, and you should also make sure that your beneficiary designations wind up being consistent, with that will. So at times I'll have a second marriage with children from the prior marriages, and the husband will have those non-probate assets, and I'll have him or change the beneficiary to be his wife, but from the wife to the trust. That way, the assets will be available for use during her lifetime, but upon her passing, his kids will be benefiting, not just her children. So that's one particular thing that you can do. And the other, as I said before, you can do some upfront money as far as making sure the kids get something rather than having to wait for their step parent to pass away. Mm-hmm. And the other thing also is to be making sure that you don't have a lot of joint ownership, because joint ownership typically passes to a survivor. I don't think you should go crazy and do this with your standard checking account, but any other bank accounts or brokerage accounts should be in what's called a tenancy in common. So really, when he passes on, his half will go through his estate. She passes on, her half will go through her estate. And if one person, by the way, contributes more than the other, it doesn't have to be 50-50. You can say, she put in 70%, he put in 30%, and you can divide the tenancy in common that way as well. So there's some creativity that you can do, and it's not really, overbearing. I think when someone says, well, gee, that's, if you love her or love him, you should take care of them. The answer is yes, but you don't have to torpedo, the relationship you have with your children at the same time.
Right. There's a balance there. You just got to find it. Yeah. Yeah. It's whenever we talk, it's just the main theme is just get your ducks in a row. Make sure that you talk to someone who knows what they're doing and do it right the first time. Then you don't have those problems.
Yeah, I'll make one other thing just before I forget. There's one thing I tell people not to do, and I may be I'm not sure if I'm the minority or the majority, but there's a thing that's come out over the years called contracts to make wills. And basically it's, I'm married the second time and my new wife and I are coming in and we're signing our wills. We'll also sign a contract saying that we're not going to touch the wills. We're not going to do anything to disturb our property, such as, but oftentimes that is a question of enforcement, because let's say I pass away and the person I chose to marry is not so fond of my kids or whatever, or she wants to do some extra, she could start just gifting away a ton of money during her lifetime. Now, the agreement's going to say you can't do it. The problem, however, becomes one of enforcement. So that's why, even though if you have a will that says you have a contract, leaving it outright is still a bit of a problem, because in that case, let's say she's given the money away to her kids and a couple of them are just bad with money. Well, you might be able to get judgment against them, but good luck collecting. So yeah. I've said it a lot of times over the years when it comes to court cases, estate planning, getting a judgment's easy, collecting is another thing altogether. So I really encourage people to make sure they get some sort of trust mechanism rather than do something that's, simple or, entrust somebody with the contract.
Mhm. Well, great advice as always. All right. Well, thanks for joining us on the Estate Blueprint. To learn more, to schedule a consultation with Tom Begley, visit begley3law.com. That is the number 3 in there. And, hopefully this episode helped you out, gave you some information. Please feel free to leave us a review, subscribe to our channel. We got lots more stuff coming your way. Tom, great seeing you again. Thanks so much for all the insight.
Thank you very much. Have a good one.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.